hey. Okay, so I'm listening to this DJ who got inspired by Skrillex. He's super young. Disco Lines, a new good DJ that I just found. So sorry for anyone who's hearing impaired. I think better if I have some music in the background. So I went to the courthouse and sat at the computer for, I believe, about 90 minutes reading up on cases. That looks stupid. How do the braids look? You're covered in hair gel. Ugh, sticky still. Okay. So, Law Snoop. Okay, first things first, Chancellor ate an assist docket Monday morning. I wondered how they could even prosecute him for giving false information to law enforcement. So they gave him a little 10-day sentence on that previous case, but I believe Clark Fry is his lawyer. I forgot to check again, but I believe he is, and he noticed something needs to be checked up on that Monday morning ate an assist docket, which is both good and bad because it can kind of lead to indefinite detention with the backlog at the Oregon State Hospital. But in some ways, it's better for people that have a very high-risk lifestyle on the streets. So, okay, I did not take notes on the Mandy Simonson case, but I had attended the hearing yesterday for a motion to strike, and I realized I needed to do more reading beyond what I could find online with the just like online news articles. So I read the original complaint, the motion to strike. I kind of read fast, like kind of skipped little bits, but the judge put it under advisement, which means they need more time to look at the supporting case law and documents and citations and motions, etc. Why is my face paralyzed? Do I have Bell's palsy? Is this the side that's paralyzed? Trying to work on that. So, yeah, I think I do have some kind of paralysis left side. Anyway, so the Mandy Simonson case, basically where it's, okay, we've got Fig versus Stephen with a V. Stephen is representing Laura Phelps, who is suing Mandy Simonson. Mandy Simonson's lawyer is Fig, maybe William Fig, I'm not sure. But Mr. Fig is basically arguing that it is an anti-SLAPP. Gosh, I really am paralyzed today. What's that? Probably on the... Anyway, so the anti-SLAPP concept is basically strategic lawsuit against public participation, and Mandy Simonson's lawyer is like, even if the information is kind of like negative or boorish, it still falls within Oregon constitutionally protected speech and U.S. constitutionally protected speech. And so this is the case of a Warrenton school teacher, Laura Phelps, who she's basically suing for economic damages to her reputation and defamation, which I don't know if her lawyer told her, but defamation doesn't really go over so well in America, where we have such a broad understanding of free speech. But her lawyer pointed out that Mandy's lawyer needed to blur the background on the WebEx, which Mandy's lawyer appeared by Zoom. And there was a little technical goofiness with like trying to get over a PowerPoint. And I told Laura Phelps I liked her shoes. She wore some really glittery rhinestone shoes. And after reading the case, I mean, the complaint, I feel like in a way she's suing because she feels like it's necessary to clear her name and clear her record. But I don't totally agree. I don't know. I kind of actually see why the judge is like, hold on a second. Because whether or not it should advance as a defamation or intentional infliction of emotional distress or intentional infliction of economic damages, and they were like abbreviating those, I don't know. So, okay, now the juicy thing, which I was like, how do I summarize this? I think I should call the courthouse and get the full case file mailed over. You see the Cisco carpe strangulation injury, guys? It really happened, bros. Stop strangling women. Stop dislocating their hyoid wound and all that. Especially non-consensually, but just its consent is no defense, as you find out from the Oregon state law annotation on strangulation. But anyway, oh my gosh, I was going to call it Emily Rainica Never Fails to Disappoint. So I have largely ignored her case in 2025 because I went to her little trial for her school board whistleblower case, where Craig Hops and his cronies, Heidi Wintermute up at the school board, want to throw Miss Emily Rainica under the bus really hard while they give Craig Hops an easy, like, basically a golden parachute out once it finally becomes exposed that he had run over Carol Epling. And even, I feel like I'm the only one talking about the correlation between the school board misconduct regarding the Carol Epling grievous bodily injury $7.9 million lawsuit and the school board's aggressive campaign against Emily Rainica. I see a correlation because it's almost like a false flag event to put a lot of harshness on her while they do their like easy way out for their little crony who's going to trial in December for his grievous bodily harm. See, that's the swollen lymph node that's really just, it's probably pressing on my nerve. Ew, that's horrible. Okay. So I read basically Emily's got her whistleblower retaliation alleged wiretapping case, which I think is absurd, on appeal. She has put the city of Astoria on notice of a civil suit against I just have to read the whole notes, and that's the frightful part, because normally if one was like in the 2025, one would just take a JPEG so one could have a clear, at least a JPEG of what's going on with this case. And instead I have to go through the court to get a copy of the file. But anyway, let's see, put down these, let's see, blah, blah, blah. Okay. Failure to record the grand jury. So basically, Alex Thomas impaneled a grand jury to have Emily Rainica prosecuted for attempting to go to the hospital to gain an email to complain about her mistreatment regarding her arm injury. So yeah, she's getting prosecuted for going to the hospital. And as it turns out, by her filing, it appears the hospital staff assaulted her, colluded and lied with the police officers to lie that she assaulted them when she was blocking their assault. And then the prosecutor withheld exculpatory evidence of the footage. And furthermore, police officers even deleted information in her phone that would be exculpatory when they had her in cuffs. And that was Officer Duryea forcibly taking her phone out of her pocket while she was being detained in Hansen's car. Hansen long rumored not to be able to make arrests for various reasons. And Officer Duryea apparently lied to imply that he was the arresting officer once she put Zachary Stockton on notice that he was being sued for his perjury in the previous school board case. These are my glasses from like 2008, and I found that they actually work as better reading glasses, but I'm having trouble. They're quite scratched up. Okay, DJ, maybe I'll stop you for a second. Okay, failure to record, failure to instruct, all body cam, Duryea, Stockton, Hansen. Alex Thomas withheld exculpatory evidence from the first grand jury. Then he had to re-impanel a grand jury because maybe they messed it up. Amber, okay, so Amber is this security lady at the hospital, CMH, admits to Hansen and Stockton, tells Hansen and Amber admits to physical contact. Paula Larson, I think, was the supervisor called in. Amber assaulted Emily. Brett's statements later contradicted in grand jury. Hansen holds them in the car. Duryea deletes footage, destruction of evidence, and then I put, ooh. Juicy, yeah. Okay, 10, Amber Lacey, Brett Byers, Zach Stockton, and Arthur Duryea all committed perjury at the grand jury October 17th, 2024, with Alex Thomas. HIPAA violations at the objection of the grand jury were elicited from Amber Lacey and Alex. She says that he did a very suggestive line of questioning and permitted the HIPAA violations to continue. December 19th, 24, second grand jury with only Amber Lacey, Brett Byers. Duryea was appearing now by WebEx, which she takes issue with. The exculpatory evidence continues to be withheld at the December 19th, 2024 second grand jury. And so for people who don't know why that's important, the exculpatory evidence would tend to exonerate, okay, including body cam. Let's see, all right. The exculpatory evidence includes Amber Lacey admitting she initiated the physical contact to strike and punch Emily Rainica. Oh my God. The footage withheld and the punch was blocked. Why do you even charge this as a burglary? When you go to the hospital, you're presuming to receive a service. You're not committing a burglary. There's nothing to support any concept of burglary other than fabricated hyperbolic charging. Let's see, so I'm reminded of the issue when Tim DeGandhi got hit by the car. I was just kind of like, oh wow, so he's just thrown onto the street with all these staples on his head and can't move, and his legs are injured, and he's just going to be melting in the sun on a hot day. And Hansen kind of picked up on the vibe. So when he negotiated for Tim to get readmitted to the hospital, he was like, oh, be careful about a lawsuit. So look at Hansen got called in on this. I wonder, he didn't, let's see, he isn't implicated in the perjury per se. He was just sort of assisting those who were. Brett standing, okay, change to Stockton, charge. Oh yeah, so this Brett guy, he was standing next to Amber when the Amber assaulted Emily, but he changes his statement to Stockton, and then he changes his statement again to the grand jury. So Sergeant Duryea opens Hansen's door, forcefully removes phone, deletes the exculpatory evidence of Duryea and Stockton criminal. Basically, she said criminal conduct, and I could say criminal misconduct. Alex Thomas, the young prosecutor, in the indictment, asserted Duryea and Stockton appeared, which Stockton did not. Duryea was on an unsecured meeting platform that is not approved by Oregon revised statute. The grand jury, December 19th, he used very suggestive line of questioning once again to elicit perjury from Lacey, Brett Byers, Amber Lacey, Brett Byers, and Arthur Duryea. He intentionally withheld exculpatory evidence. The prosecutorial misconduct is willfully negligent, malicious, sloppy, and a procedural error. The Oregon legislature in 2017 demanded all grand juries be recorded. By failing to record the entire thing, she's alleging that Alex Thomas was, the whole thing needs to be tossed out because it's a violation of that. That the prosecutor has willfully broken the law and is overzealous and malicious prosecution. Oregon Revised Statute 132.250.1a, that's point 30, 28, 30. So Emily, when she was represented by David Beal, listened to the recording. Let's see. 31, Stockton did not testify. And Duryea did not testify in person, but he was stated to testify in person, so that the indictment was essentially false. False information. Stockton was left out because of the appeal on 23 CR 00379 due to Stockton perjury. And it is clear that he colluded with Thomas. Oh, she was saying that in the trial, this is the school board retaliation case that Amanda Benjamin finally backed out of. Way to go. You know, that was sticky. Dirty work for Clatsop County. It was clear that Thomas colluded with Stockton. There was a lot of prompting. She was like uncertain face, body language. Is this the right way to answer it? Is this the right way to answer it? And basically she said that Thomas's stunt has backfired. Okay, so 32, Derriere colluded with Stockton to falsify the report. And this is when I just started almost copying word for word because it was getting so juicy. Let's see. Derriere arrest off body cam proves Derriere not arresting Stockton as was reminded, subject to civil lawsuit relation to 23 CR 00379. Stockton blew off or denied, and what it appears is that the city of Astoria failed to notify attempts to verify. Failed to notify them, but Stockton and Derriere later checked and found out that the city was served notice of a claim regarding Stockton in a civil action. So Derriere approval approval of Stockton report, knowingly intent falsified that Stockton police report in his police rep to indicate that he was the arrest officer to unlawfully deflect liability from Stockton. Then November 24, city served notice of claim to torts by Stockton and Derriere. So Derriere had a motive to lie, and he lied to the grand jury, which is the Class C felony, December 2024. Okay, December 19th, 2024. Okay, so 33, police reports are under penalty of perjury. Stockton and Derriere their witness cannot be used as evidence. It demonstrates an intent to falsify and lie. The court should cite Stockton for perjury, credibility, for torched. I love this. She's a great writer. The credibility torched beyond salvage, or recognition in this matter, and frankly in general. 34, Derriere. Let's see, appearance, December 19th, 24, is not legal at all, not in the manner listed on the indictment. Oregon law does not allow WebEx for grand jury. Colluded from home due to the night shift, that maybe because he doesn't want to testify. He was subpoenaed and he shouldn't have falsified his reports. 132, 580 regarding 4 lists of witnesses effects of deficiency. States if witness not listed on indictment or how appear not listed, witness not allowed to let. If court overlooked how appearance not listed, instead it cannot testify or ask that you disregard that discrepancy. It would violate laws, affect the material rights of the defendant, demonstrate bias, preferential treatment, subject case to overturn on appeal, and waste state resources. Prosecution of a non-crime. Felony non-crime. Clatsop County classic. Okay, 35, Amber lies. Okay, we got the lying witness. Alex withholds the exculpatory. Brett Byer lies, and Alex withholds the exculpatory. Alex, the prosecutor, Alex Thomas, the young prosecutor. 37, HIPAA violations. Oregon nurse and violation of the Oregon Nurse Practice Act. Patient physician privacy is violated. This is currently under investigation by the Oregon State Board of Nursing, and the Oregon Patient Safety Commission and Governor Kotek have asked the Oregon State Board of Nursing to investigate Brett Byers because of his role on the Oregon Patient Safety Commission. Bros. Okay. And this isn't even the hot stuff that's rocking the district attorney's office that we know of. What the heck is going on up there? Nobody's telling. Written reprimand. Yes. So he could revoke his RN. He could get a written reprimand, strike buyer testimony, invalidate the indictment. Alex used, and here's the thing, this is wonderful. She points out that Alex Thomas, the prosecutor, used pending matters inappropriately to ask for an increased sentence in the CR case with the last number 79, violating the constitutional presumption of innocence under the Oregon and U.S. Constitution, Article 1, Section 11, and Article 1, Section 16, and the Due Process Clause, the Fifth Amendment. He is overzealous for his ulterior motives and is sloppy whilst breaking the bedrock principles and laws of the Oregon and U.S. Constitution. So asking for enhanced sentencing due to other pending cases that you have a presumption of innocence was unfair, especially as he's the one who's piling them on. Okay, so getting into the Oregon Rule of Civil Procedure and the Oregon Rule of Criminal Procedure, Alex is not pro se. She had this lovely point about how he's not a pro se defendant who is given all this latitude by the courts for messy work, essentially. It's not an oops. These are serious errors. And if he is given slack for these errors, it would violate the constitutional protection and rights to have the indictment invalidated and dismissed because he screwed up badly, and the indictments should be dismissed with prejudice. The motion to dismiss with prejudice